before we do anything else, excuse me, but I'm determined that this is going to be a 40-minute talk. And I'll explain that in a minute. But the first thing I want to say is, in terms of the title of this talk, from Singh to C-31, what ... happened, I'm quite upset with the direction that this Conservative government has gone. I wanted strong language, but I was persuaded by James that this is an academic setting, and one should go only so far. And it was Michel Millard who very cleverly suggested a series of dots. I was comfortable with that. Although, James, I have to say I've changed my mind. Actually, this is a very mature audience. I think you can take it. So I want you to know that the original title was From Singh to C-31, What the Heck Happened? And I apologize for the strong language. I'm sure that a lot of you were thinking of exactly the same word. The second thing is, I am determined to do this talk on time. Therefore, my good colleague, Audrey Macklin, uses her cell phone as a timer. So I, too, will have reverted to high technology, so I'm going to use an egg timer to make sure I'm on time. So here we go. And so from Singh to C-31, what I'm really going to talk about is the arc of Canadian refugee history from the Singh decision going through to C-31. And so what I'll be looking at, first of all, is what I think was quite a positive view of refugee determination that followed upon the Singh decision. I think that there were two significant acts that happened in 2001 and then 2010, which narrowed it, and then I want to look at C-31. I'll discuss that in considerably more detail, and also talk a little bit about why I think that they are doing it. So that's what we're really going to talk about tonight. Let's talk about the Singh decision, but I'm going to skip some stuff, partially because Howard's already told you, so I don't have to repeat it. But Supreme Court of Canada decision from 1985. And it was really the springboard of the Canadian refugee system. So that's really what I'm going to be talking about, the Canadian refugee system. And, well, first thing I must tell you first, and I'm a little embarrassed to say this, partially because my wife is present, but I actually was seduced by Madam Justice Bertha Wilson. Well, to be more precise, I was seduced by the precision of her decision in Singh, because it was clear, it was incisive, and it was very thoughtful. And as Howard pointed out already, taking the interpretation of Section 7, referring to everyone, and everyone means everyone. If you're on Canadian soil, you're amenable to Canadian law in her language. And that was a very, very important part of the decision. Essentially, in terms of the refugee system that was in place at the time, there was the claimant never got to talk to the decision maker who made the decision. They could speak to an immigration officer. There was a transcript of the interview. It was sent to Ottawa to an organization called the Refugee Status Advisory Commission, which gave a recommendation after looking at the transcript and other materials. They made a recommendation to the minister. If it was rejected, then there could be an application for redetermination to the Immigration Appeal Board. But in making that argument, they never really got to see the basis of the decision. So really, in terms of the refugee system in Canada, what the court said that was really the core of the decision is this: my greatest concern about the procedure is not the absence of an oral hearing, which most people think. It's not that they weren't concerned about that in and of itself, but with the inadequacy of the opportunity for a refugee to state his case and know the case he has to meet. So in some sense, what I'm talking about tonight is quite narrow. I'm talking about refugees, how they tell their stories in a judicial setting, how we create a system so they're able to do that or not do that. And it's based on this basic presumption. If we have signed the convention that says We do not remove a person to persecution. They have the right to claim for the protection. So the issue is, how do we let them tell their story? How do we create a situation how they can actually tell their story? So where we go from there is that with that core idea, it took Canada 4 years, from 1985 to 1989, to actually create a refugee system. Much of the system was based on a report that was written for the Minister of Immigration at the time, Flora MacDonald. It was written by Rabbi Gunther Plaut. It was very insightful in its understanding of the refugee claim process. And actually, one of the people that made interesting submissions to that report and actually was quoted in it on more than one occasion was Howard Adelman. But in terms of the report itself, there were certain things that it said. The first one, in terms of the refugee hearing itself, it is essential that the Refugee Board hearing be of the highest possible quality. In order to ensure this, claimants must be in the position to present their case fully and completely and must have access to counsel. So, what does that really mean when we think about it? Well, what it's saying is there must be sufficient time to prepare and present the claim, and there's a need for legal representation. So that's our starting point. Another key point, the lack of evidence. So the Refugee Board should recognize that much of the testimony given by the claimant be unsupported or unsupportable by independent evidence. Unless there is reason to doubt the truth of the statements of the claimant, he or she should be given the benefit of the doubt and the statements accepted as true. So it recognized, again, one of the principles of refugee law is most of the evidence, and not just documents, but also witnesses, is over there where the persecution took place, and they're often unavailable, particularly to somebody who's fled that country. So there should be some respect for the words of the claimant, and in actuality what it usually amounts to is presumption of credibility unless it's shown to be otherwise. So, with refugees as witness, because that's what happens, much of the evidence has to be through the mouth of the claimant. Refugees should be questioned with sensitivity and an appreciation of their suffering. Allowances must be made for their fears and their situation. For these reasons, the refugee hearing should not be adversarial, but rather a cooperative inquiry. So it's the notion of the vulnerability of claimants as witnesses, of refugees as witnesses, and I could go do an entire lecture just on what that amounts to, but I think a lot of people in this room already have a sense of that. So what it says is it should not be an adversarial proceeding where you can beat the refugee up in terms of the questions that you ask. So that's the refugee as witness. Then we get to the boldest statement of all, helping refugees tell their stories. This should indeed be the goal of the refugee hearing, to assist the refugee in presenting his or her claim as effectively as possible. I think certainly the government of today would find that to be a very radical view, but if that was somewhat the starting view, certainly if we looked at just the narrow history of the board, you see a slow diminution of that process where it becomes more and more of an adversarial relationship. So, in summary, in terms of the view, it was a non-adversarial one that recognizes the limitation of the claimant and the evidence and takes a facilitative approach to the proceeding. Okay, so that's the starting point. When the government was actually designing the system, I must say there are other things that they had to think of, to be fair. Some of them, to give you an example of this, first of all, there were delay and high numbers of claimants then. That wasn't invented by Jason Kennedy. In those days, the same issues were there. So, for example, a high volume of claims. By 1989, there were 85,000 claims in the backlog. Delays in the claim process, it took 2 to 3 years to have your claim heard by the Immigration Appeal Board. Concern about fraudulent claims, they used to call them in those days mucks. What a kind word, manifestly unfounded claims. But Rabbi Plaut discussed them considerably in the report and ultimately rejected them in the notion that somebody be given a lesser procedure or no procedure because they were from some presumably safe country. Here's a quote from Flora MacDonald, who was the minister of the day after the Singh decision, and the report went to her. I assure honourable members of the House that the new policy will adhere to our humanitarian traditions and respect our international obligations. What we have tried to do throughout is to seek a balance between fairness, efficiency, and humanity. Now, to be fair, if you hear the words of any government leader in any of the developed countries, you always hear the stuff about fast and fair, fair and efficient. The Brits love to say fast, firm, and fair, and most of their statements are completely insincere. However, in this case, I think actually, Flora actually meant it. This was a government that was concerned about the humanitarian quality of the process, and they actually were looking for, at the end of the day, the way to identify people who legitimately needed protection. So that's our starting point. What was the result of that? Very quickly, I'm going to give you the core of what was the refugee system from 1989 up and through. It started to lose parts and pieces of it in 2001. But every eligible claimant had a right to a full quasi-judicial hearing. The board and members were independent, tremendously important. In most preliminary refugee decisions, refugee policy, the views of the government, are relevant to the decision. 2 members hear and decide each claim. That was revolutionary from other ones. If the members differ, the decision is positive, so it was called the benefit of the doubt principle. There was a right to counsel. Please note, though, and this becomes critical, only at the claimant's expense, because refugees are so rich when they arrive in the country, of course. The hearing procedure was non-adversarial, so they stayed, they were faithful to that. There were no formal rules of evidence, so for any lawyers in the crowd, corroboration, notional hearsay evidence, none of those were applicable. That's the refugee hearing officer, the RHO, was supposed to be neutral, not to oppose the claim, and I could give you an entire lecture just on the changing character of an RHO over the last 20 years. The documentation center was there for information, not just for the board, but for the claimant. So when this notion you can't find the evidence, you could make applications to the documentation center to assist you with information. And it was very important for any administrative tribunal proceeding, there were written reasons for at least the negative decision. So that's really how the system worked. How well did it work? Well, first of all, let me say, the buzzword at the time was first decision, best decision. It was the Canadian view that you give this one really good opportunity for the refugee to tell their story. And it was, at the time, highly praised by the UNHCR, and it was seen, that portion of it, as a model system to be followed by other countries. In terms of how it worked, well, in the beginning, the acceptance rates were pretty high. 84% the first year, and anybody who's followed acceptance rates will realize that that's through the roof. It went down to 77% in the second year, but by 1996 it came down to a 44% acceptance rate. And from that date all the way through to 2010, it actually, the acceptance rate, it took a while for the board to learn its business. It really went back and forth between the low 40s and the high 40s. And quite frankly, that's a remarkably consistent acceptance rate. If you looked at most countries, you were looking at roller coasters like that, where they would go up and down, not because of refugee flows, actually because of refugee policy within the country itself. Claims were ordinarily somewhere between 25,000 to 35,000 per year, so that moved up and down. I want to talk about the 3 principal flaws in the system, because there were 3 major flaws. The first one was the members of the board were appointed by the federal cabinet. They're called GIC appointments, Governor-in-Council appointments. Virtually no qualifications were required. The law said 10% of the entire core of board members had to be lawyers. The cabinet policy said you had to have a university education or 6 years equivalent professional experience. And knowing some of the people who got onto that board, they had a very broad notion of what professional meant. Rabbi Plowden's report had stressed it was important to have competent, experienced decision makers. So this was the one area where the government, Governor Brian Mulroney, did not follow the advice of the report itself. And unavoidably, political patronage reared its ugly head. So the appointment, and more importantly, the reappointment of members often raised the political factor of whether or not they were connected. And there was this notion within the board, is it an issue of connection or competence? And it would go back and forth. But it was very problematic because the result is there was great inconsistency in the competence of the individual members and predictably great inconsistency in the results of their decisions. And unfortunately, there were a significant number of badly reasoned decisions, both positive and negative. It did severe damage to the board's morale and to the board's reputation. There were two other flaws in the system. I mentioned before right to counsel, but no state-sponsored counsel. Because of that, first of all, you did not have to be a lawyer. You could be a lawyer or not a lawyer. There are only two classifications of human being in this world. Is that correct? Lawyer and non-lawyer. Do I have that right? In any event, consultants were engaged. Some legal aid systems provided support, some did not. The result was, again, tremendous inconsistency in the quality of representation. Some magnificent, some of them are my best friends here in Toronto, magnificent advocates for any area of law. At the same time, outrageously incompetent and indifferent, fraudulent work sometimes by other consultants, and unregulated by the Law Society, the board, or any other agency. The third flaw was the lack of an appeal. In the beginning, there was an appeal to the Federal Court of Appeal with leave, but it was a relatively general leave standard. By 1993, the Federal Court of Appeal wanted out of the refugee business. Although they actually had laid some excellent early decisions down, the Canadian jurisprudence was widely respected for its liberal interpretation of the Refugee Convention, with, and Sean will say, with some exceptions, because there certainly are some exceptions to that. However, by 1993, they were replaced with a leave application to the Federal Court Trial Division, and it was only judicial review. So, first of all, you had to get leave, and that leave rate went very quickly down to about 10 to 14%. And it may not mean much to you, but leave where there are no reasons given why it's denied, you then have an opaque process that takes place. And secondly, it was only judicial review, it was not appealed. So that became very problematic, and those were really the three principal flaws in the system that in some ways worked well, and in some ways didn't. Okay, I'm going to flash forward to 2001 and the first changes that happened. So this was the Immigration Refugee Protection Act. The government of the day, so we're talking in 2001 May, I hope that date strikes you as relatively important. The government had a couple of principal concerns. The first one, it was taking 13 months for the first hearing to take place. The annual claim flows had, by 2001, had increased to 44,000 from around that mid-20 average. The board was only funded for 25,000, but now I am talking like the chair of the board, right? I'm into all the numbers and productivity. But these are factors because it affects the way in which individual hearings are heard. There was a backlog of 45,000 claims. The two-member system had created a kind of scheduling gridlock. And the government wanted more decisions with the same number of members. So the obvious solution was going to a single-member system. So they said, okay, there's only going to be a single member. However, they recognized, because the brilliant and outstanding chair of the board at the time told the government, you cannot have single members with the kind of appointment system that you have, because there are too many lousy members in the board. That's a technical legal term, lousy. It's Latin, I think. So that was the problem. So they said, okay, we're going to have an appeal. The Refugee Appeal Division was created. It would only be a paper review, but it was going to catch the mistakes, the really obvious bad mistakes. So that was the theory. They also, because the government did not have an overwhelmingly negative view of refugees at the time, they broadened the definition of refugees to include persons in need of protection. So there were certain other areas such as torture, right to life, those sorts of things. So they actually broadened out the definition. And they also introduced the pre-removal risk assessment. So they said, anybody who's refused, you don't get sent out of the country until there's a last-minute review of your risk. There may be new evidence, or there may be old evidence that wasn't available at the time. So we're going to make sure if we send someone back that they're not going to be at risk. However, they also kept the GIC appointment process. They didn't want to give that up, and they wouldn't even put the appointment process into regulation, so it was subject to some scrutiny. If you talk about, well, the expression that's often used for appointments is it's the royal jelly. This is the power to appoint is something that's almost like a kind of political currency, and they were greedy. They did not want to give that up, even though they knew it caused so many problems for the board. So the result was the Immigration Refugee Protection Act. It was passed in May. There was an intervening event that occurred on September 11th of 2001. The act hadn't gone past the Senate yet. It was past the Senate, but I must tell you, there was discussion of not passing the bill to make something that was much more draconian. And I cannot understate the concern that arose. It was the linkage between the notion of refugees and national security. It was completely incoherent. They didn't really know what it meant. They didn't know. It was the influence of our American cousins and all these rumors that refugees from Canada had somehow been involved in the September 11th event, which was complete nonsense. But it changed the character of the government's view of refugees. They were somehow more dangerous. They arrived with undocumented documents. They arrived from strange countries. So somehow this has to be of concern. One of the ways in which that concern was expressed is when, in the following May of 2002, they actually implemented the new system. They didn't include the Refugee Appeal Division. They left that off. They said, we'll do it in a year. Well, we're still waiting. So they never did do it, but part of the influence of that was a somewhat more hostile view of refugees as less benign. It wasn't just about numbers. It just wasn't about fraudulent refugees. There was something else to think about. And quite frankly, in a way, we had the worst of two systems, because we had single members appointed by governor and council appointees, and the only safety net was this application for leave to the federal court, which was itself an opaque process. So, and we've seen since then, and it's the work of Professor Sean Rehag, who's in the audience, tremendous studies of both of all the inconsistency of the acceptance rates of board members, then the inconsistency of the leave rates at the federal court. And academics like Sean and myself start talking about lotteries and what the hell happened to the justice, what the heck happened to the justice. But that is a very real concern, that if we're concerned about coherence and laws and definition, that it loses coherence if you've got what look like very similar claims, or you've got a member with a 1.5% acceptance rate and another member with a 70% acceptance rate. Then you're just talking about lottery. Which member do you get when you show up at the board or when you show up at the federal court? So those were the challenges. In terms of the pre-removal risk assessment, there were problems from the beginning. To make it brief, first of all, there were long delays in getting them done. Very, very poor quality decisions by the CBSA officials who were making them. And at the end of the day, there was about a 2 to 4% overturn rate where they reversed decisions. So they went a long way for very little result. There were also, at the same time, everybody knows what I mean by H&C, Humanitarian and Compassion. You could make an application on humanitarian compassionate grounds to remain in Canada, an application for permanent residence. It's not formally a part of our refugee system, but in actuality, there was somewhere between a 25% and a 40% positive rate on those applications. We don't know for sure because they don't always separate out refused refugee claimants from others. But the result was that we were seeing a lot of people in legal limbo here, a refused claimant, no fair reconsideration of their case by the board, stuck in Canada for 2, 3, 4, 5 years, and then ultimately permitted to remain for humanitarian reasons. That's because they're the head of the PTA at their school by then, and they've got 3 kids in school, and they're very Canadians. It's a lot of the facts were not the risk factors overseas, but establishment in Canada, and they looked and sounded like great Canadians. So there was a fairly positive reaction to that. However, all of that drove the government crazy, and that was the liberal government. When the conservative government came in, they really were driven crazy, and they finally came up with Bill C-11 in 2010, which was the Balanced Refugee Reform Act. What they wanted to do was quite horrible. Unfortunately, or fortunately, they couldn't do it because they had this inconvenient thing called a minority government. So they had to compromise in all kinds of ways. I'm not going to go through all the details of the Balanced Refugee Reform Act because you'll find out very quickly a lot of it was taken back. But they wanted to make a much, much faster process. They did offer to finally put in an appeal, a refugee appeal division. That would be even better than the other one that was never implemented. There's a William Faulkner short story about a man who was sold the same horse over and over again. And we started to have that kind of feeling. How many times? Because it's offered up as the justification for all the nasty things they want to do. But this time we're really going to implement it. So that's really what they have done. The other thing, and I'll talk about this under C-31, they were going to get rid of the governor and council appointments and appoint public servants to be the decision makers. So that was interesting. I'll talk about that under C-31. The one thing, though, they did right away, because they did it right away, is that they wanted to get rid of agency right away. They didn't like it. It means that people that are fraudulent come to Canada because they can stay under agency. Because they were a minority government, they couldn't get rid of it, but what they said was the compromise was, well, you can still apply for humanitarian compassion grounds before being removed, but we can remove you before the decision is made. So we would know, it wouldn't mean that a lawyer couldn't go to court on an extreme case as a kind of toehold to persuade the court for them to stay, but for many, they would be removed. The other thing they did was they said, well, humanitarian compassion talks about undue hardship, all the horrible things that could happen to you. But they said risk factors concerning persecution, that's not part of it. Well, that's when law merges into surrealism, because nobody knew what the heck it meant. So it means that I can still complain about horrible things that would happen to me because I won't get a job, but the fact that one of the reasons those happen is people beat me up now and again because of my ethnicity, I can't mention beating up, only to not getting a job. It's bizarre. But that was put into place when the act was passed in 2010, and that is the law now. Let me move on to Bill C-31. Jim, how am I doing for time? The thing about egg timers, I told you that I'm using high technology. I'm not very good with technology. I forgot to push the damn egg timer. My wife who's in back will tell you this is not a new story. How am I doing for time?
Good.
10 minutes? 15. Good. I'll see you at 15 and out. So let me tell you about Bill C-31 in terms of what it's about. Because here's the horrible stuff that it really does. And here are the big problems with it. First of all, timelines. So what we talk about is timelines. When you make a refugee claim now, you've got 15 days to deliver a written document to the Immigration and Refugee Board. Under the current system, you have 28. What's the big difference between 15 and 28? Well, the difference is with 15, you don't have time to go and find a lawyer. The lawyer doesn't have time to get legal aid approval because the approval has to be for the cost of the interpreter as well. You don't have time to actually draft a coherent, reasonable decision that really is true and complete with your story. There just isn't time to do it. So what does that mean? That means there will be documents that are filed that will be hasty, that will be incomplete. Then the Immigration and Refugee Board, what do? They say in their rules that you swear to the truth and the completeness of the document. So even if you're, and by the way, a lot of people will be unrepresented because they can't get the lawyer, and then what will happen is that the board will hold them accountable for every tiny error and omission that is contained within that document. So they know and understand that that actually subverts this notion, this key notion of having the opportunity to tell your story. In the hearing itself, you will have either 30 or 60 days. The hearing will be established right away. Remember Rabbi Plug talked about evidence? That's not a lot of time to get the evidence in a lot of cases, particularly if it's medical evidence, particularly if a person has, is a truly vulnerable claimant. They need a psychiatrist report or a psychologist report. Try getting that if you're poor with no resources in 30 or 60 days. It is not going to happen. We don't know whether the board will grant adjournments or not, but we're expecting a very, very stiff view of adjournments. So, but we've got the appeal now. They've given us the appeal. The problem with the appeal is, I'll get to that in a minute. The problem with the appeal is this, that you've now got 15 working days to file the appeal after your hearing's over. Right now, it's 45 days for judicial review. 15 days is ridiculous. It's impossible. Again, you've got to find a lawyer. The lawyer's got to look at the transcript. It costs $700 for a transcript. Then you've got to file it. It will not happen in 15 days. To make it even worse, what they've done is they've then, and I'll show you the list, they've taken 6 categories of claimants that say you don't even get the appeal. So what they gave in the Balanced Refugee Reform Act, for 6 of them, they took them away. I'm going to show you what those 6 are. But before I do, here's a parliamentarian talking about C-31. So here's the first thing he or she says. Canadians expect us to maintain a just and generous refugee determination system, which we have. That could be Flora. It sounds like Flora. But also, that is not subject to abuse, where we do not see and continue to see thousands of people coming from safe democratic countries making refugee claims in this country. This is not acceptable to Canadians. So, question, who is that? Jason Kenney. Good guess, and you're wrong. Who lays behind Jason Kenney? Ah, there he is. The right honorable. So, but that, I just put that in to contrast that with Flora in terms of the difference of the contract. So there are your time limits. There's your refugee appeal time limits. Here are the 6 ones that do not get any appeal. Not only do they not get an appeal, they can apply for judicial review. However, they don't get an automatic stay of removal while the court's thinking about their judicial review. They can be removed immediately unless they go to the court and persuade the court that there's something so compelling in their case that the court will order a stay of removal until they think more about their case. We don't know yet how the court is going to react to that. I'm hoping the court will be generous. Others think otherwise. They have not shown a record of generosity recently. Oops, you can't see that yet. So, those are some of the problems with the act. The other one is the designated country of origin. That was Bill C4, excuse me. And then did I do that right? Sorry, I didn't. The designated country of origin is the concept of a safe country. So this is the notion that some people, because they're from a safe country, only really get 30 days and then no appeal because they're from a safe country. The problem is, a lot of people feel that the concept is fundamentally wrong. A country that's safe for some people is not safe for others. A good example would be LGBT claimants that are from countries that are reasonably civil to other people other than LGBT people. The Roma would be another good example where some people are having a fine time in the country and some not so fine. So that is a particular problem because they get less of a process. And think about it. They only have 30 days, but they don't get the appeal. They're in greater need of the appeal than the people that get 60 days. The second one is the designated foreign nationals. So these were originally the people in Bill C-4. These were the so-called boat claimants that the government really wanted to do nasty things to, such as put them in jail for a year if you're in the group, man, woman, or child, unless you could show that you're so decrepit or so young that you shouldn't be in jail. It was quite horrible. It was reduced in Bill C-31, but it still says the following, that you're mandatorily, if a group is designated and the minister has virtually arbitrary powers to designate, the result will be that you're mandatorily in jail for 2 weeks. There's a detention review, but if you don't have an identity document, you may not win your review, which means you're in there for another 6 months. And if there's any large number of people in that group, you will be in a medium security penal institution. So think about that. People that are refugee claimants who nobody's even considered their claim, so they can be incredibly vulnerable, and they can be put in mixed criminal populations in Canada. And that's still available. The second thing, and once again, I won't go on to the other things will happen to them, but in terms of a refugee claim, they have to prove the refugee claim while they're parked in a penal institution somewhere. So once again, tremendous burden to prove their claim, and no appeal once again, and rapid removal. I won't go on with the others, but it gives you a sense of what this act is about. So what I'm really going to, the one last thing I really want to talk about, because I've had to skip a lot of detail here, it's all because of the egg timer. This would go much more slowly if I had my egg timer. What I want to talk about is why. Why are they doing it? Because it seems that it's quite mean. First of all, they have 3 false notions. I'll do them quickly in terms of what they think. First of all, they think the IRB decision-making process is the principal cause of delay. It's never been the principal cause of delay. It's actually the removal process that had 2 and 3 and 4 years attached to it. And they ignore that because that's not the judicial determination part of it. The second thing is the principal cause of the delay with the board was the government itself 4 years ago did not appoint and reappoint new members. There were Liberal members coming due. They didn't reappoint them and didn't appoint new ones while the claim flow was going up, and they created a backlog that went up to 60,000. In actuality, that backlog is now down to 35,000. So even with the current board complement, with enough time in reduction of the backlog, they actually could manage the process. But that's inconvenient information too. The second one, and this is critical because it's the key part of the government's rhetoric. Fraudulent, refused claims or failed claims are not necessarily fraudulent. But that is the key message that the government repeats again and again. There are 90% of Roma claimants are phonies, are false, are bogus. But it's not true. Many, many refugee claimants are refused for technical reasons. Classic example, because there's state protection, internal flight alternative. The threat from the drug dealer is seen as criminality. It's not seen as persecution. They're refused, but they don't even understand why they're refused. Their fears are completely legitimate, but the government characterized all of them as fraudulent claims. And the classic example are the Mexican claims and the Roma claims in that regard. But because of that, there's not only just a huge stigma on refugees, but they create that as the reason for why they have to have these super fast policies. The last false notion in that regard is the faster the better. The truth of the matter, even for fraudulent claimants, that most of them are acts of desperation, even if they know that they're not refugees. They sell their businesses. They spend all their money on tickets, purchasing false identities. There's tremendous dislocation when they come to Canada. That if those people are returned within 9 or 12 months after a legitimate hearing, a reasonable and decent appeal, it's just as devastating if what you want to do is really deter fraudulent claims. You're able to do it. You don't have to send them back in 46 days in order to deter them. But the government isn't interested in hearing that. But the reason they're not is because I will say, when this nitpicking over 15 versus 30 days to provide a written document, 15 days instead of 40 days to do an appeal, it's silly. But the government, it's not silly from the government's point of view, because in actuality, it actually discloses their true motive. And that's what I'm going to finish on, the two motives. Is that okay, James? Here are the two principal motives that they have for why they are being so harsh and so cruel to refugee claimants. The first one is that you're suspicious just because you came to Canada because it costs money to get to Canada. The logic goes like this. You've got money to get here, that means you've paid smugglers for fraudulent identity documents to avoid the visa barriers. You have supported organized criminals. Even worse, if you've arrived with a group, they're really bad criminals because they're traffickers that you've given the money to, which makes you worse. You've arrived without documents at all, which means you've destroyed documents which were purchased from criminals. Or if no visa is required, that means you're from a civil democratic country, like Hungary, and therefore you're probably not a refugee at all. So it's a perfect little catch-22. You're stigmatized either because you got involved with criminal organizations to come to Canada because you needed a visa that you couldn't get, either that or you didn't need the visa and you came from a country that therefore is one that would be seen as a safe country. So at best, you're a second-class refugee and inherently suspicious. But here's the coup de grace. Here's the second reason, which is the one that's I think, very important to understand, which is this. The government has a different view of international protection. Although as signatories to the convention, we recognize an obligation to grant protection to anyone who arrives, what they really think is the proper procedure for refugees is to seek protection in the first accessible country of refuge. If it entails going to a refugee camp, so be it. If that requires a delay of 17 years of being in the refugee camp, which is the average time in a refugee camp, by the way, before resettlement, so be it. If that entails unreliable protection in a non-signatory country, like Thailand, where you're liable to arbitrary arrest, or you're liable to be arrested and actually removed to your country of nationality, so be it. But if you come directly to Canada, which is not the most accessible country unless you're claiming from the United States, you're automatically suspect. If you get to Canada, you've had to bypass primary countries of refuge, and that makes you the worst of Canadian insults. You're a queue jumper. So let's look at what the Parliamentary Secretary, Rick Dykstra, said about that. Queue jumping is not fair. It is not fair to people in our country, and it is not fair to those who have been determined to be refugees to come here. That principle on which fairness exists has to start, and this legislation would help do that. What they've done is this very tricky thing where they've flipped the moral card around. So instead of the refugee being the victim of persecution, they've become the opposite. They're not fair. Who are they not fair to? Well, they're not fair to Canadians. I'm not quite sure how that is, but they're not fair to, and they're really not fair to all of those wonderful, queued up refugees who are putting in their 17 years in those hellhole camps in places like Dadaab before they come here. Now, it's complete nonsense. There is no queue. There's no access to refugee camps from several locations, such as Thailand, and even more than that, there is no obligation within the convention to go to the nearest country of refuge. But once they've made that premise, it lets them be moral and self-righteous, because they couldn't be that mean and nasty to refugees. They know that they're being unfair, but the reason they're justifying it is you're not really a refugee if you came to Canada. There's a moral stigma, and that justifies all the horrible things that we're going to do to you. I was going to talk about what the antidotes to that, but we can hear that in terms of comments and questions. So that's it. Thank you.